The final matter to come before the court this morning is Cynthia Palazzo versus John Palazzo. I note that we have a cross appeal in this case, and it's my understanding from our magistrate that there have been some discussion about who will be commencing the oral argument first. Has there been an agreement?
Yes, Your Honor.
Yes, Your Honor, there has.
And in what order will we be hearing this morning?
We're going to present initially on our appeal for 5 minutes, and Ms. Grasky will reply for 5 minutes. Then Ms. Grasky will present on her appeal for 10 minutes, and I will reply for 10 minutes. And if Ms. Grasky chooses to take any part of her 5 and 10 that I've just suggested and use it in the end as her rebuttal, she can choose to do that.
Reiterate the last part of that agreement for me. Sorry.
So it would be 5,
Five
and I will
five.
tell you it would be 4,
Okay,
and then
11.
10 and 9, and I'm basically looking for 2 minutes at the very end. Thank you. And we appreciate your help with that. Thank you.
Well, and if it gets muddled in my mind and I start talking about passage of time, you all can keep me on track as well.
Okay.
The court has read the briefs. We're ready to see who you are.
Thank you, Your Honor. Good morning. My name is Richard Rabb. I represent the appellant, John Palazzo. The appeal before the court this morning is a relatively simple and straightforward, we believe, issue. The first consideration here is, what is the standard of review? And we believe that the standard of review is de novo. We think that this court can stand in the shoes of the trial court and determine whether the trial court had jurisdiction to hear the case in the first place, and whether this court, by ruling previously, had determined the law of the case. And both of those discussions are de novo versus abuse of discretion. The appellee argues that this is an abuse of discretion consideration, and we do not believe that that is the case. The standard of review here, we believe, will drive the entire case. The statute, section 2303.21, talks about the reference to the Court of Appeals decisions, and hence how the transcript costs are to be determined. And they give that discretion to the Court of Appeals. The statute relied on by the appellee is a Title 31 statute that represents litigation costs. Clearly, it's not in dispute that this Court of Appeals previously ruled on the issue of the transcript, and it's not in dispute that following this court's ruling that the appellee returned to the trial court, made the same filing there, and now suggests that the appellee should not cite to general division rulings by this court, but rather should look to this special domestic relations statute. And I don't believe that the statute even refers to transcripts. I think it talks about litigation costs, and that transcripts, that specific cost, is addressed separately by statute and by rule. And we believe that it is law of the case, and that the trial court was wrong. They didn't have jurisdiction. They shouldn't have ruled the way they did on granting their request to have Mr. Palazzo pay 50% of the transcript cost. Thank you.
May it please the court. My name is Leslie Grasky. I'm here on behalf of Cynthia Palazzo. This is the first time we've heard a standard of review from Mr. Palazzo. In fact, his brief argues that App Rule 24 governs. And the case law that was cited in the brief deals with Appellate Rule 24. After the cases cited interpreting Appellate Rule 24 were decided, the legislature came up with the statute that says you can get costs of litigation, which has been known to include the cost of the transcript. When this court ruled on wife's original request for a transcript expense to be allocated to husband, he immediately withdrew his appeal. On that information, this court properly could rule that he shouldn't contribute because he no longer had an appeal. The wife did prevail on several of her issues, and the matter was remanded on other of her issues. And the trial court appropriately interpreted that that would give it the permission to allocate the costs fairly between the parties. We believe that this court should affirm the decision of the lower court on that basis. Thank you. Bring my notes up. I didn't bring all my notes up when I came up first. May it please the court. Contrary to husband's assertion, this court didn't remand this matter for only 2 issues. It did remand for consideration of the officer loan, and the trial court properly said, you took all that money for yourself, pay half to her. This court also said that the trial court's initial finding that there was no evidence that could support financial misconduct was error. And the trial court looked at that and said, I don't believe that was financial misconduct. And this court then ordered the trial court to recalculate property division and consider security and interest. And the court said all other orders remain in full force. And this court said after you finish property division, as ordered by the statute, you'll look at spousal support. And the court, again, left its previous decision in effect. Turning to
Did they make findings about that? Did they say why they did that? Or
No.
were they silent?
No, especially as to the spousal support, there were no findings. The husband in this case committed financial misconduct as to the JZM account. There's a lot of evidence in these several days of record about his taking money for himself, but we're only focusing on JZM for purposes of this appeal. This is where the trial court said there was no evidence at all. Just as in Buccolo, the husband in this case, unlike in Buccolo, the husband in this case wrote checks directly to himself. He didn't badly invest money as he had been badly investing money all along. He took money to himself. When he was questioned on the stand, he said he was tired of all those document requests and snooping. Well, he was doing this before the divorce was filed, so he had no reason to be tired of that. Unlike Buccolo, this was a different use of the money than in the past. The parties had used Frontline to pay personal expenses, and they had written those off in their books as officer loan. This was JZM. It was just a limited purpose account. It held construction money, and it paid the mortgage and construction expenses.
Given the parties' past contact with the money from Frontline, what is the act of financial misconduct?
Because JZM was a separate account. In fact, it was the proceeds of a loan that the parties would have to pay through the business. So it's a very distinct entity, and they had not done anything like this before. The wife had been the sole owner and had written the checks, and she had never written personal checks from JZM. Exhibit Z shows all the checks she wrote, which ended in October of 2010. Husband admitted that she never wrote checks for cash. He wrote checks for cash and said, I think that went to real estate taxes. But the record shows that real estate taxes were paid by JZM. He said, oh, it might have been an American Express bill. Well, there's no receipt, no canceled check. Might have been tuition, no receipt, no canceled check. Who drives to Purdue with a suitcase of cash and doesn't even get a receipt? That was his testimony the first day of trial. And there were many days of trial after that where he could have presented evidence of a legitimate use of that $38,000. This was a different way of treating JZM money than they had ever done. When the court then awarded the wife some money for the Frontline loan, it tacked it on to 10 years of payments at 0% interest with zero security. Normally, when a court awards one party an asset, they get the asset and they pay the other person. Now, they may get a payment plan, but the payee gets a mortgage on the house, which is usually the asset divided that way. So that there's no chance of the person just selling the house and continuing to pay a limited payment plan. This becomes even worse because it's 0% interest. The trial court gave Mr. Palazzo $400,000 of assets, secured it with nothing, and then ordered her to carry that note at 0 interest. So he could, today, sell the business, put the money in a bank, earn 10% interest, and pay her 0% interest at $3,000 per month. It's clearly unfair, and this court has recognized it's unfair in the Arn decision, because it will take 11 years to pay this off at $3,000 a month with no interest. The trial court then exacerbated that error some more by counting that $3,000 property division payment as wife's income when it calculated spousal support. In fact, the court at one point also calculated spousal support without including that, and husband had $130,000 in income and she had $44,000. So the court actually thought about it and still said, don't want to be unfair to the husband, I will include this as wife's income. Now, if she'd been given $400,000, which she could bank and earn 10% interest, it would have been proper for the court to say that 10% interest every year is her income. It's not proper to say she has an asset with no security at 0% interest, and that should be counted as her income for spousal support. It is the inverse of double dipping, where a business is valued for its stream of income, and then the stream of income is used for spousal support, but it's not proper for her payments to be counted as her income when the court looks at what spousal support should be awarded. The court actually did a fin plan calculation, and it does count the $30,000 and $36,000 a year property division in its stream of income. Husband says
That's what's referred to as maintenance? That's what's referred to as maintenance on the fin
no,
plan?
in the fin plan it just says non-taxable income. You know, if you gave her the house, for example, you wouldn't impute income to her because she doesn't have to pay rent. You know, if you keep using the real estate as an analogy for this property division, it's very clear. She's not giving something that can earn her income. She is only given something that is interest-free, without security, and then is double-dipped, and the court determined her spousal support. So we are asking that this court divide the $38,000 of unexplained draws from the JCM account. We're asking that the court to order at least a stock pledge, but preferably a real estate mortgage on the property division payments and an appropriate interest rate. We would propose 3.84% because that's what husband thought was good to pay his father.
Just as a question, is it possible to take just a lien, a judgment lien?
We don't have a judgment. The court pointed that out and said you can't have interest because it's not a judgment. That might be a reasonable solution. But an interest-free loan of $400,000 to be paid over 11 years is not an appropriate division of the assets in this manner. Finally, we would ask that this court...
Counsel, as a reviewing court, you're asking us to order?
Yes, I am, pursuant to the appellate rules, which permit you to put in the order that should happen, because we've gone back once when you've said, look at this, and nothing happened. You know, it is in the interest of not only equity, but judicial economy, for this court to award what should be happening here. Thank you.
I have a lot more this time. Thank you again for your consideration this morning. As it relates to the brief that was filed here by the cross appellant, again, the standard of review is very important for this court to consider. First of all, the standard of review for everything here is abuse of discretion. with the exception of financial misconduct, which I'll talk about in a second. But we all know what abuse of discretion is, that it's got to be so grossly and perversely wrong that it spikes the mind. So we don't think that any of that exists here. The standard review for financial misconduct is, hang on a second, is the manifest weight of the evidence. And manifest weight of the evidence, the case cited by the cross appellant is accurate. It's Bucalo, Bucalo. And in that case, it says you consider the manifest weight of the evidence in the same standard as you would consider it in a criminal context. And that exceeds an abuse of discretion. That says that after review of the entire record, which we assume the trial court did, that after the trial court weighs all the evidence and all the reasonable inferences, including the credibility of the witnesses, and we know that the trier of fact is in the best position to do that, then there is some determination by the reviewing court that the trier of fact lost his way. He created an absolute miscarriage of justice, is what that case says. And that such a determination is only overturned in the exceptional case. The first assignment of error set forth by the cross appellant is that the trial court failed to follow the remand from this court. So what has been referred to in the briefs as Palazzo number 1, which is this court's decision and journal entry of March 31st, 2015. The court sent this back, and it said, as it related to assignment number 2, in paragraphs 24 through 26, they asked the trial court to look to see whether they could find financial misconduct, to consider the evidence of the withdrawals and how to treat, not a determination that it be marital property as suggested by the cross appellant. And has the standard been met for a distributive award? And the only way you get to the distributive award is that you have a finding of financial misconduct. So those specific findings are addressed by Judge Quinn in his subsequent decision regarding the remand here. What their first assignment is, and if you read the text of what they wrote, it's not that Judge Quinn didn't follow what this court ordered. In fact, nowhere in their argument do they talk about that. I know Ms. Grasky mentioned something this morning, but that's not in their brief. What's in their brief is that they don't like what the decision was. They don't like that it wasn't marital property. They don't like that there wasn't financial misconduct, and therefore no distributive award. So we believe that the first assignment, that they're wrong as to the first assignment, that Judge Quinn did follow this court's order of March 31st, 2015 in his ruling. As it relates to his ruling as to those specific items, I would say that Ms. Palazzo, as the cross appellant, has very selective recall of what the facts in this case are. And I direct the court to the brief that was filed by us as the cross appellee on page 5 of the statement of the facts. The statement of the facts that Judge Quinn knows and that the record provides is that Mrs. Palazzo used the Frontline American Express. She wrote all the checks from Frontline International, which is the underlying company here. And all of this was used for both personal and business. And the record is replete. All of the exhibits and the cites to the transcript are contained in that provision. As it relates to JZM, this was a newer asset. This building was not even occupied until late 10 and into 2011. And it's a building that has 3 liens on it. So when we get to the security argument and discussing whether there should have been a lien on the building, we can see from the judge's original decision that there was nominal equity in this building to start with. Further, what we'll see from the court's decision is that there were 2 liens with financial institutions, one with the city of Akron. And the two with the financial, though I'm not sure about the city of Akron, do have restrictions, and putting a lien on there is not as easy as simply saying it ought to be there. We believe that the judge's ruling as it relates to assignment number 1 was accurate. There was no financial misconduct here. They took an isolated fact and they turned it into financial misconduct instead of taking all of the facts and discussing them. And I would suggest to the court that even within the briefs and the assignments where they say that the record is replete with evidence, where they say that Mr. Palazzo did not comply with the temporary support order, they don't cite to the record. They don't cite a judgment entry. They don't show where it's been replete. Okay? The fact is here that there is no court order that Mr. Palazzo didn't comply with the temporary support. There's no finding of arrearage in the final divorce decree. So it's mere statements by the cross appellant that somehow these things are out there and it's unfair. And we heard Ms. Grasky this morning talking in that regard, that this is simply unfair, and we don't agree. The second assignment of error, Your Honor, that they raise talks about the security and interest, and we argue this in our brief in 2 separate sections. First of all, it ignores the fact that they were provided with security and interest. In the divorce decree itself, they're provided with life insurance in the event that Mr. Palazzo dies. So that's going to be covered. Number 2, the judge also said that if he fails to pay, that it can be reduced to judgment. In the case that we cited, you'll see is that if it's reduced to judgment, then in fact, that's when an interest rate applies. That's when the statutory interest applies, not some interest that we're going to make up here. But interest is not appropriate. And the 2 cases that they cited, we differentiated on. And it's interesting that there is no support, no legal support, no case law, no statute for the argument of security or interest that's contained in their brief. The 2 cases that they cite are easily distinguished, and you'll see in our brief, by example, the one that they referred to about a lien on a home. That was the case they cited. It was about a lien in a home, and also talked about where payment's going to be in 7 years, not where payment's made over time. So I think that those are easily distinguishable, and with that, you'll see, Your Honors, that there is no legal support for those arguments either. As to the third assignment of error, which is the spousal support and the consideration of the property division payments, I would say a couple things. Number 1, exhibit number 1 in the judge's original decision is a fin plan that he ran. And he also references the brief that was written by the cross appellant in this case. And he runs guidelines, he runs a fin plan based on that and what they would have proposed. And it's not dissimilar about what they're arguing here, where Mr. Palazzo would have had 25% of the income. That's what they would say. And what their brief argues, which is, I believe, completely counter to 3105-171 and 3105-18, they argue that the 2 statutes are not intertwined. That is, in fact, what they say in their brief. But I think when you take a look at what we've argued, Your Honors, you'll see that they are absolutely intertwined, and that the relevant sections of the statute for consideration here are 3105-18C1, A, I, and L. Those are the 3 subsections. And they talk about why do we divide property first? We divide property first under 3105-171 so that we can see when we get to 3105-18 what we're going to do. So that in and of itself, the statute 3105-171 says You got to do this first before you get over there. Further, Your Honors, if you take a look at 3105171C3, and you will also see in that provision, there's discussions about consideration of the property division between the parties. It's an element in the spousal support considerations. I mean, it's all statutory. And again, the argument here in cross appellant's brief, it specifically states that those two briefs are not, or statutes are not intertwined, and we disagree with that. And in reviewing exhibit number 1 to the judge's original decision, you'll see that he properly ran those numbers. And it's important to note on there, because sometimes when you're not familiar with fin plans, to appreciate what they say. But you'll see there's a line marked adjusted gross income. And on the adjusted gross income, that's where the judge applies taxes. The inference is that somehow this non-taxable $36,000 a year property division that Ms. Palazzo receives is somehow being included in her income. And it was improper to do something like that. So Judge Quinn did not include it in her income. It's a cash flow issue. There's a difference here. And there's no equalizing income in the state of Ohio. There's no equalizing income in this district. And the inference that she is somehow entitled to some different number, although that's not briefed for them, it's certainly the inference, is just inaccurate. And we believe that Judge Quinn properly did it. If you followed their reasoning and their proposal, which Judge Quinn also reviewed based on their trial brief, you'll see that the division between the two of them was 75-25. That's the court's exhibit number 2 attached to the original judgment entry for divorce.
And counsel, I need to inform you that you utilized your 15 minutes of time today. Thank you.
Thank you, Your Honors.
May it please the court, Ms. Palazzo would ask you to consider her brief when you consider what her arguments are, rather than a restatement of them. We realize that the statutory scheme for dividing property and determining spousal support are related. We never argued anything contrary to that. As to the financial misconduct, once again, we're trying to drag the two businesses together. The parties did use Frontline to pay personal expenses. They booked it against officer loan. When the valuation came in, they said, you need to do that as salary, not as officer loan. Well, the officer loan was depleted by husband taking $195,000 and buying college accounts for 3 children, 2 of whom had graduated college, to make sure there was not much in that officer loan. But you can see from the evidence, there's no evidence of wife using JZM for any personal things. There's no evidence of anyone using it for personal items until John Palazzo gets it. And then he writes checks for cash. He thinks they're for real estate taxes, but no, we have the checks for the real estate taxes. They're in the record, they're cited in the brief. Exhibit Z. When he writes a check, he just doesn't want to be snooped at. But it's before anything like discovery was occurring. This was financial misconduct. He took money in a way that's different from the past, and he took it for himself, and he deprived his wife of it. As to security, I'd like to know who in this room would like to lend $400,000 with no security at 0% interest. It's beyond comprehension that the court would load all of the risk on the wife. He could literally sell that business, put the money in a bank account, earn 10%, and pay her no interest for 11 years.
Wasn't the court's position, though, that if she were given security and he had none and the business went out of business, He has more risk, equal risk.
Okay, well, it's just like a house. You get the house, you give the other person a mortgage on the house and streams of payments. If the house burns down, it's because you got the house. I mean, some of the things you can't cover. Sell the business, divide, I don't think that was a good option either, but the court does not divide assets and put all of the insecurity on the receiving spouse at 0% interest over 11 years. We're not asking, there are so many ways you could do security here. You could put security on his personal house, that won't hurt the business. You could do a stock pledge, so he can't sell the business without satisfying what he owes his wife, just like with the house. It's just appropriate security for someone who's waiting a long time for money and at 0% interest. That problem is compounded when you make that into spousal support. You're using the same dollars that are her property division and putting them in her column because the court did decide to equalize income. That wasn't appealed as an erroneous decision, so to hear an argument that that wasn't right is a little late now. I guess that could have been heard in the first appeal and then he could have paid half of the transcript costs. But the court determined to equalize, and then it uses property division to do that. It is clearly against equity and against the appropriate use of the statute. Again, the court considered spousal support without the property division, and when it awarded her $18,000 a year, husband ends up with $150,000 and she has $34,000. That's essentially what the court did by using her interest-free loan on $400,000 as her income. We would ask that the court issue orders that would divide the frontline money that was taken by the husband and order some security for the wife's $400,000 property division and interest. We proposed 3.84 because that's what husband thought he should pay his father. It's an appropriate number. And finally, we would ask that the court award the wife's spousal support pursuant to the spousal support calculation presented to the trial court. Thank you. And we appreciate your accommodation on the time with this kind of unusual case. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the website. Thank you. We are adjourned until next Tuesday.